Hello friends, welcome to another video. In this video we'll be continuing with URDG articles, article number 14. This video will be very useful for people who are appearing for CSDG examination. If you're new to the channel, then please subscribe to the channel and press the bell icon so that you'll be getting the intimation whenever a new video is coming online. Also at the end of the video, if you like the content, then please press the like button. So without wasting any time, let's get started. Let's look at article number 14. So we have a case over here. BG issuance date is 1st Jan 2021, effective date is 1st Feb 2021. So demand cannot be presented between 1st Jan and 31st January. BG expiry date is 30th September 2021. The BG issue places some branch in Mumbai. Alright, now the guarantee is calling for two documents. One is the demand and another is copy of unpaid invoice. So what the first point says in article number 14, the presentation is to be made at the place where the BG was issued. If the BG was issued at some branch in Mumbai, then the presentation is to be made only at that branch. Beneficiary cannot make presentation at any other branch in Mumbai. Alright. Second, the presentation is to be made on or before the expiry date. So any presentation which is made after the expiry date, the guarantee ceases to exist. So by default, guarantor will not be accepting any presentation after the expiry date. First, whichever branch issued the BG, that branch will only have the right to accept any demand, and that right or that obligation to accept the demand will only be till the expiry date. Okay. Next one. Beneficiary has a particular option in URDG that beneficiary can make partial presentation of documents and tell the guarantor to wait. So for example, beneficiary made presentation of only this document, which is copy of unpaid invoice, and beneficiary told the guarantor that you hold on to this document and the remaining document will be submitted in due course. In that case, the guarantor will hold on to this presentation till the expiry date. The moment expiry date is gone, guarantee is gone. So URDG gives the facility to the beneficiary to present documents in parts. Now, in what cases the documents will be presented in parts? Suppose this document is required to be signed by a particular official in beneficiary's company, and that official would be traveling in a short span of time. So what beneficiary can do? Beneficiary can get this document prepared and submit it to the guarantor, so that half of the documents required under the guarantee would be complete, and then the beneficiary can say that you hold on to this document, the later part of the remaining documents I'll be submitting in due course. So in that case, guarantor will hold on to this document till the expiry date. On the very next day, beneficiary loses its rights to claim under the guarantee, and guarantor has also no obligation to send a refusal notice to the beneficiary, because when this document was presented, beneficiary itself told the guarantor that the presentation is incomplete and will be completed in due course. So when the presentation is incomplete, guarantor has no obligation to check the documents also. So beneficiary has a facility to present documents in partial manner, provided it informs the guarantor that the presentation is incomplete and it will be completed in due course. Otherwise, if the beneficiary is not giving any intimation, the moment this document is presented, in absence of any instructions from the beneficiary regarding the completion of presentation after some time, guarantor will check the documents and send the refusal notice. Point number C deals with forms. So point number 3 has two wordings, form and format. Form means with a paper or electronic. Format would be PDF or JPEG or Word or any format. This format is the way or the manner in which an electronic document is prepared, basically the extension. This is what would be the mode of preparation, whether it is paper or electronic. Format is a subcategory of form. So if a guarantee is silent, by default presentation is to be made in paper form. If the guarantee says that demand can be presented in electronic format, if the wording of the guarantee is just that the demand can be presented in electronic format, but in what electronic form the guarantee does not specify. So the beneficiary can present the demand in any of the formats, provided that demand is presented at the address which is mentioned in the guarantee. So the complete clause in the guarantee would be demand can be accepted, or demand can be presented in electronic form to XXX mail ID. Now that mail ID can be a common mailbox of that branch or the mail ID of the branch manager. So if the branch manager receives a claim from the beneficiary which is in electronic format, that will be acceptable provided we are able to authenticate it. Authenticate, the definition of authentication is when it is applied to an electronic record, the receiver should be able to identify the identity of the sender. So if the beneficiary is XYZ Limited, now many times what happens is when this is the name of the company have their own email extensions. So the name of the person can be abc@xyz Limited. If this is the mail ID, then the guarantor would be able to know that this is the mail ID of this company. So the identity of the sender is known, and whatever was sent is received in intact form. There has been no alteration done with respect to the content of the demand. Alright, so if the guarantee does not specify in which form demand is to be presented, demand can only be presented in paper form. If the guarantee says the demand is to be presented in electronic form but does not specify which format, then the beneficiary can present a demand in paper form, or beneficiary can present a demand in electronic form with any of the formats. But in that case, the demand will only be acceptable if the guarantor is able to authenticate it. All right. Another aspect to this is if the electronic record, if the guarantor is not able to authenticate an electronic record, then it will be deemed as if it was never presented. Okay, next is if the guarantee restricts the presentation to be made by a particular mode of delivery and it does not explicitly exclude any other mode of delivery, then any mode of delivery would be acceptable. So let's understand this by examples. First, guarantee says presentation to be made only via registered post. So in this case, if the presentation is made by any private courier, it will be disregarded. It will not be acceptable because the guarantee categorically says presentation is to be only made via registered post. So only demands sent to the guarantor via registered post will be acceptable. Another case, if the guarantee says presentation to be delivered via DHL and any other company is prohibited. In this case, if the presentation is delivered by any other courier company other than DHL, it will be disregarded or it will be rejected. So if the guarantee restricts the mode of presentation with a particular courier company or with a particular mode, then it has to be followed. Whereas if the guarantee mentions in general terms, then any mode of delivery can be used, provided the demand reaches the guarantor on or before the expiry date. Let's look at point number F. We have company A, company B. Now guarantor has issued 3 guarantees for these companies. wherein applicant is the company A, beneficiary is the company B. One is BG number 1, BG number 2, BG number 3. These are the guarantee reference numbers. BG number 1, issuance date is 1st January 21, amount is $100,000. BG number 2, issuance date is 1st January 21, same, but amount is different, $105,000. BG number 3, the issuance date is 1st Feb 2021, amount is $110,000. Now, company B presents a demand and it says that this demand is under a guarantee which was issued on 1st Jan 21. Now, this is the only line which is mentioned in the demand which links the demand with the guarantee. Now, can you identify with this detail that this demand is presented under which BG? Because this satisfies with this also as well as this also. So I cannot identify under which guarantee this demand is presented. If I cannot find out under which guarantee this demand is presented, I can either go back to the beneficiary and ask and tell the beneficiary to give me the exact BG reference, or I can try to find it from my own records. So if I try to find it from my own records, the time for examination of documents, which is 5 business days, will not start unless and until I find out under which guarantee this demand is presented. Now let's look at another example. If the beneficiary presents a demand wherein the beneficiary says the BG was issued on 1st Jan 21 for amount $105,000. Now in this case, I am able to identify that this demand is matching with the issuance date of BG number 2 because the amount is matching with it. So from this demand, I can identify under which BG it is presented, and I can start checking this particular demand. Now, every demand under URDG is required to mention in what respect the applicant has breached the contractual obligations. This is called as statement of breach. So the beneficiary has to, in general terms, mention that what exactly applicant has not performed because of which the claim has been lodged under the guarantee. This statement of breach can be there in the demand itself or can be presented as a separate document. So if we have 3 BGs, beneficiary has presented 2 demands, one under BG1, one under BG2. Now beneficiary has only presented a demand but has not presented the statement of breach, because what beneficiary did, beneficiary presented this demand and mentioned statement of breach will be presented at a later date, so you hold on to this demand. So when the statement of breach is presented as a separate document, it has to link under which demand it has been presented, because unless until it links itself to the demand, I will not know whether this demand is to be paid or this demand is to be paid. Okay, nothing over here will result in nothing over here, if it is not properly followed, will trigger the checking of the demand. Unless until all things are in order, I will not start checking the demand. Okay, next is any document which is issued by or on behalf of applicant or the beneficiary are to be in the language of the guarantee, which includes demand as well as the supporting statement. Any other document which is presented by any other party other than applicant or beneficiary can be there in any language. Next is article number 15. Article number 15 deals with statement of breach. Any demand must be submitted along with a statement of breach. That statement of breach under a guarantee would be a statement wherein the beneficiary is mentioning in what respect applicant did not perform as per the underlying relationship. Now the underlying relationship for a guarantee is the contract. So beneficiary has to mention, for example, if the contract was for shipment of shirts, okay, then beneficiary can present in statement of, or can mention in the demand as, the shirts were not shipped as per contract number XYZ. This statement is required because tomorrow, if there is a court litigation, or there is some issue and the matter goes to court of law, then the guarantor should have a written document signed by the beneficiary, wherein the beneficiary is explicitly mentioning that something did not go right as per the guarantee terms and conditions, or as per the performance which was agreed by A in the contract and was also listed in the bank guarantee, because of which beneficiary is lodging a claim. So bank needs a written statement signed by the beneficiary that in what respect things went wrong. Beneficiary is not expected to write or to give details, but in general terms this particular thing has to be mentioned. That is called statement of breach as per article 15A. Now another aspect is 15B, which is applicable for a counter guarantee. Now similarly, bank Y has to mention that they have received a compliant demand under the guarantee which they have issued. 15A deals with beneficiary mentioning that in what respect there was a breach in the underlying contract. In case of counter guarantee, there is no underlying contract, so the only obligation or the only instruction which is given by bank X to bank Y is, you have to issue the BG as what I have mentioned in my CG document, and bank Y is entitled to claim as per the terms and conditions of the counter guarantee. So 15B requires bank Y to declare that I have received a complying demand under my BG. That's it. Okay, so this is a statement of breach for guarantor to claim under the counter guarantee to the counter guarantor, and in what respect applicant is in breach with respect to the underlying relationship is the obligation that, or is the statement of breach that beneficiary has to mention to the guarantor when claim is being lodged under the guarantee. Now as per article 15, this requirement is by default there in the guarantee. If the guarantor or the parties wants to waive this requirement, it has to be explicitly mentioned that requirement as per article 15A is waived, applicable for a guarantee, and requirement as per 15B is waived, applicable for a counter guarantee. Okay, now what article 15D says, suppose we have a guarantee which is issued on 1st Jan 2021, effective date is 1st Feb 2021. So the claim cannot be lodged from 1st Jan 2021 till 31 Jan, and the expiry date is 31st of March 2022. Beneficiary presented these documents. Now these are called for as per the guarantee. Demand cannot be dated between 1st Jan to 31st Jan, because this is the period wherein beneficiary is not allowed to present a demand. The same goes for this supporting statement. If it is presented as a separate document, cannot be dated between 1st Jan to 31st Jan, because again the effective date BG is, although BG is issued, but BG is not effective until 1st of Feb. Any demand or any document, basically any demand can be presented on or after 1st of Feb only under this particular BG. So these two documents cannot be dated between 1st Jan and 31st Jan. Whereas the copy of unpaid invoice can be dated before this date. Okay, so the copy of unpaid invoice which is presented along with demand or supporting statement can be dated 1st Jan 2021. That is okay. But these two documents cannot be dated before 1st Feb 2021. Also, any of these documents cannot be dated after the date of their presentation. That means future dated. So if these documents are presented on 2nd Feb 2021, they cannot be dated as 3rd Feb 2021. Future dated documents not acceptable. Alright. Article number 16, information about the demand. So whenever you as a guarantor receive any demand, you have to immediately inform the instructing party. Or if there is an applicant, you have to immediately inform the applicant, so that the applicant or the instructing party can have a word with the beneficiary to understand that in what respect the beneficiary is not satisfied, and then they can decide the way forward. Similarly, if a demand is presented under the guarantee which is backed by a counter guarantee, so the guarantor has to immediately inform the counter guarantor. Counter guarantor will immediately inform the applicant that something is not right between you and the beneficiary, please sort it out, else I will be making the payment if the demand is compliant. Okay, if you have any questions related to the content or related to this particular training session, please post your questions in the comment section. Have a great day. Thank you.